has to be. Everybody ready? You ready for us to go? Okay. All right. I would like to call the Board for Licensing Contractors meeting on November 19th, 2024 to order. Start with a roll call on my left.
Bill Dement, here.
Reef Smith, Franklin.
Andy Allen, Kingsport.
Mark Broad, Knoxville.
Randy Chase, Nashville.
Keith Whittington, Johnson City.
Ronnie Tickle, Memphis.
Jennifer Ransom, Memphis.
First thing on our agenda is to adopt the agenda.
Make a motion, we approve the agenda.
Second.
Any discussion? Okay, all in favor, say aye.
Aye.
That motion carries. Move on to approval of the meeting minutes from the previous meeting.
Move for approval.
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. All right. Temporary license approvals. Must have some of those. Is there a motion to approve them?
Motion.
Second.
Any discussion? All in favor of approving the temporary license approval, say aye.
Aye.
That motion carries. We'll move on to approving the waived applications, or waived interviews for applications.
Make a motion, we approve waived applications.
Second.
Any discussion? All in favor of approval of the initial applications with waived interviews, say aye.
Aye.
Any opposed? That motion carries. We'll look at the contractor revisions for increases, add classes, mode changes, and name changes. Is there a motion to approve those?
I'll make a motion, we approve all revisions.
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. LLEs, LLPs, and home improvement licenses.
Move for approval.
Is there a second?
Second.
Any discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. All right, applications with factors and interviews.
Move for approval.
Mr. Chairman.
Oh,
Before
we have
you
discussion.
approve on that, there is a matter that we need to discuss.
Okay. Can you guys hear me now?
Yes.
Okay. There is a matter, if you recall from the last meeting, that you asked me to follow up on with an applicant that you interviewed. We were going to check on pending litigation and some pending complaints that he had. I did follow up, and I believe based on what I found, the board needs to consider this as a whole and take a vote on it. So just for a brief background, this applicant owner, he owned a prior company, if you recall from looking at this, and you guys all should have this this application in front of you on your iPads. He had a history of complaints with that prior company and discipline with the board. He let that license expire and applied for this new contractor's license. And then following the interview, you had some concerns you wanted to check on. So here's what I found. He did have pending litigation that is currently still in play. And in short, he did lie on his application. The application was submitted April 21st, and when he was asked on that application, do your persons associated with the business have pending litigation arising out of the field of construction, he answered no. And so at the time of answering that question, he had 2 pending legal proceedings that arose out of the field of construction against his prior company. And in fact, the court documents show that he was served just 2 weeks prior to filling out this application. He was served with one of those lawsuits. And then the online court records show the other lawsuit was pending at the time that he filled out this application. His prior company, and I'm not sure if this was disclosed in the application or anything, but his prior company is in the middle of bankruptcy as well. And so essentially those proceedings are probably stayed at this point because the applicant's prior company is in bankruptcy, and that's just the way the court will automatically stay those proceedings. So you got some consumers that are pretty harmed from that kind of stuff. So I think there's 2 clear grounds if you wish to consider denial on this application. The law states the board may refuse to issue or renew a license to any person, firm, or corporation for lack of financial stability, lack of expertise, submission of false evidence with regard to the application of license or renewal. That is where you have a ground. Submission of false evidence with regard to an application of license or renewal. He has lied on the application, and he also lied to you during the interview about the pending litigation. And there was also a complaint that was closed and flagged, and he said that that matter had been settled. I did follow up with that complainant. They ultimately did not cooperate with the complaint because they had found out his prior company filed for bankruptcy, so they didn't feel they had the resources to want to pursue that. But the issues were not settled in that complaint that was closed and flagged. Do you have any questions or anything that you want me to clarify before you take a vote on the application?
What classification was he wanting to be licensed in?
Let's see. Kathy, do we have a copy of that application for the board members? It was BCA.
Okay. Anybody want to make a motion?
I'll make a motion to deny the application.
Second.
Any other discussion? All in favor of the motion, say aye.
Aye.
Any opposed? That motion carries. All right, Kyle, we're back to other applications with factors in interviews.
Yes, Mr. Chairman.
Okay. Anybody have any of those they want to discuss? Okay, whatever interviews we had or whatever applications with factors we've approved or denied.
I'll make a motion that we approve the applications with factors, including the interviews.
Second.
Okay, any other discussion? All in favor, say aye.
Aye.
That motion carries. Okay, Fresh Start Act pre-approvals.
I believe there was one, Mr. Chairman, if you want to have any discussion or just take a vote on that.
Yeah, I reviewed it at the, before the meeting. There's one application from an applicant that had 5 years left on his probation. He wanted to know whether we would use that as a reason to deny his license.
And just for clarification for the whole board, these are pre-approvals, so he's not applied for a license yet. He's just asking if the board would use his criminal history as a reason to deny if he applied. According to the law, there's an avenue now. They can request pre-approval from the board based on their criminal history, and you're only looking at their criminal history to see if it's related to contracting, and if you would approve them to apply for an application, that criminal history is not going to prevent them from getting a license. Does that make sense? Okay.
How does an applicant know about this?
I do not know when the law changed, but it's the Fresh Start Act, and that actually has a lot of factors the board has to consider if they do want to deny a license based on prior criminal history. But in that portion of that law, the board has to, there's an avenue for the potential licensee. They can request pre-approval from a board. So they're not applying for the license, they're just asking the board.
Right, but how does the guy know that he can do this? Is it on our web or?
It should be on our website. I think we do.
Got it.
Has he indicated what license he would be applying for, or anything like that?
I believe it was an LLP. Is that?
I think that's right.
So how did you reviewed it, and what was your?
My conclusion was we would not hold that against him. It was a drug possession about 10 years ago or so.
I guess my question would be, because this did change a few years ago, we used to not let people have a license that were still on probation. And I don't know if that was in the law or it was just something that we made as sort of a group decision or what, but can we keep him from getting a license, still being on probation, or is that the purpose of this whole deal?
Give me one moment. I'll go back and look at the statute. But the pertinent decision is if the prior criminal history is related to the occupation, which I think there is not a good argument that it is in this scenario. So let me go back and check the statute real quick regarding probation. Jesse, do you? Okay. But as far as it being related to contracting, I don't know if there's enough of a nexus with the drug paraphernalia being 10 years ago, and with him with being a plumber.
And that is correct. We have to look at the conviction itself, not necessarily the status of probation. I think very often when we see probation, it's very close to the date of the conviction, and that's a factor that's considered. If the individual is still on probation for a charge, they were convicted a year ago of this offense, if it has been quite a substantial period of time that has lapsed since the date of that conviction, it does factor into whether or not there is a severity related under the Fresh Start Act.
Any more questions on that? But
Do we need to vote on that, or?
since we had some discussion, you guys need to take a vote on it.
Okay. I'll take a motion on that particular item.
Move for pre-approval?
Pre-approval.
Is there a second?
Second.
Any other discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. All right, we'll move on to the legal report.
Good morning. Some of the changes to the legal report are as follows. Number 61, case number 2024051191. The board wanted to change the settlement offer to the voluntary revocation of the respondent's license based on the discipline that the respondent had received in the past from the board. Number 71 on the legal report, case number 2024039911. The recommendation is to close with a letter of instruction that there needs to be a final electrical inspection on this project. Number 81, case number 2024033521. The recommendation is still the same, but the board's reasoning is that the board believes this matter is a contractual dispute between the complainant and the respondent. Number 82, case number 2024044501. The recommendation is to close with a letter of warning and flag. Number 84, case number 2024035281. The board's recommendation is to close with a letter of instruction that there needs to be a final electrical inspection on the project.
I have one change to announce. Number 78, that's case number 2024-047-191. This was set for discussion. After discussion, the board felt this was a definite violation of a mechanical subcontractor contracting over their monetary limit. The board's decision is to authorize formal charges for not abiding by the terms of their license and a settlement offer of a $5,000 civil penalty.
I also have one change to case 2024042091, number 40. The board has asked that the civil penalty be increased to $4,000. It was originally recommended as $2,000.
All right,
Make a motion, we accept the legal report as amended.
I want to make a change, I'm sorry. I said 4,000, I meant 5,000. You guys asked to increase it to 5,000. Sorry about that.
okay, any other discussion on the legal report? All in favor of approval as amended, say aye.
Aye.
Any opposed? That motion carries. Jesse, appeal of initial order.
Yes, morning. Ms. Sarah Lou will be stepping out as she was the prosecuting attorney on this matter.
Okay.
All right, good morning. You should have before you, or in your packet, the technical record from this case that was appealed. Just to give some background, there was an unlicensed home improvement case involving Casey Fuqua doing business as Music City Woodcrafters. After that matter was presented to the board, the legal report and a consent order were sent out. Since it wasn't settled, it proceeded with a notice of hearing and charges, and eventually led to a motion for summary judgment that the respondent did not respond to. So an order was entered against the respondent in this matter by the administrative law judge sitting on behalf of the board. And I believe a copy of that initial order should have been provided as part of the technical record, but I believe it actually should have been provided as well last month when we initially, or 2 months ago when we initially discussed this case. What we did receive after the last board meeting, we set a deadline for the respondent to file a brief, which is just a written argument as to why this case should be considered on appeal. And you should also have a copy of that letter from the respondent stated October 21st, 2024. I'm not sure if you all had an opportunity to review that, but I will note that the respondent did not initially provide this information as part of the underlying case. This was provided with the appeal. So after the order was already entered by the initial order. At this stage, the board has a couple different options. Essentially, one, it could be reconsidered by the administrative law judge. If the board wanted this to go back and have a new hearing on this matter, the board could decide to reopen this case and hear this matter in its entirety, or in a limited fashion if there was one or a few elements that the board wanted to reconsider, or the board could affirm the initial order that was entered by the administrative law judge that was sitting on behalf of the board. I'm not sure if you all had an opportunity to review the brief filed by the respondent, but it did not necessarily dispute the fact that it was unlicensed home improvement contracting, but it essentially asked for a reduction of the penalty or reconsideration of the penalty due to the fact that the respondent did not believe that this license, or was not aware of the license being required for this project. The respondent does, in his paragraph, second paragraph, make some statements regarding allegations against his workmanship. There was an underlying civil case as well from the homeowner in which the homeowner did prevail and got a judgment against this unlicensed home improvement contractor. Does the board have any questions about this matter?
How much was the fine?
I'm going to pull that back up. The The total civil penalty, because it was an unlicensed home improvement case, was $2,000. $1,000 for the violation of representing as or operating as an unlicensed home improvement contractor, and then $1,000 for the violation of the licensing statute. So $2,000 for the civil penalty, $836.50 for costs. So total $2,836.50.
On page 22, it looks like that it was $2,000, and then he can get another $1,000, which amounts to $4,000. And he only did $16,000 and something worth of work, and he already had a litigation. I'm just trying to find out why we're charging him so much or fining him so much on $16,000 when a lot of times we don't fine that high on something even bigger than that. I'm just asking for clarification.
So the $2,000 is for those two separate violations, $1,000 per violation. For home improvement violations, the board can seek $1,000 per violation. So that's why the total of $2,000 was sought. Since there was not a disputed case, a lot of times when those cases go to trial, the judge will set whichever penalty that the board or the attorney asks if there's not a dispute by the opposing party. So in a case like this, I know a consent order would have been sent out to the respondent to settle this case. If the respondent doesn't respond to that, if it goes to a hearing, the respondent doesn't show up and argue their case, sometimes those penalties are set by default.
Are we going to see a payment period?
I'm not sure if I can speculate on that. A payment has not been made at this point.
It doesn't appear likely from what I've read. So I don't know that, it's my opinion. I don't know that it does us any more good to pursue the case.
So at this point, then, the board could either dismiss the matter, which would mean no penalty at all would be issued, or essentially deny the appeal and affirm that matter from the underlying case, which would just keep that $2,000 penalty in place, whether the respondent pays it or not.
What do you think?
Has he given any indication that he's going to pursue a home improvement license in the future, or is he quitting contracting altogether? I can't remember exactly. It's not on our iPad, I don't think.
That's a good question. He has not specifically said, he didn't say in his appeal, he didn't specifically say he would proceed it. He thought that he could do smaller projects without a license. So I'm not sure if he will continue to do smaller projects or not, regardless of the penalty. He does state in his appeal as well, he says, not that I would not pay the state if they deny my appeal. So he might end up making a payment, I'm not sure.
He goes on to say, not that I would not pay the state if they deny my appeal. It's just that I have no assets, no income other than Social Security, and nothing that a lien or garnishment could attach. So he's on Social Security, and he's 71 years old, which is pretty young, so, it's just one of those things. I'm just kind of concerned what we're gonna, he'll probably continue doing some work regardless, but I don't know a whole lot that we can really do since I don't believe he can do much more. Right, he's been made whole, so, I like to just go ahead and dismiss this myself, but.
How old is this?
He's 71.
I know, but we've been bouncing this around for a year.
I believe the initial filing was April of 2024.
Okay.
I'm not sure when the complaint itself was filed. I'd have to double check on that, but that's when we filed our notice of hearing and charges.
So was that a motion? What was your?
I was making a motion to just go ahead and dismiss, but that's why it's brought before us for us to kind of decide what to do. I'm just sitting here thinking, he's already get nailed for 16,000 probably, or maybe more. And he doesn't have any assets and not much he can do about anything. It's Social Security. I'm just proud that he can even do something. So anyway.
Is there a second or more discussion?
I'll second it.
Okay, any other discussion? All in favor of dismissing this case, say aye.
Aye.
Any opposed? Motion carries.
All right, thank you.
Legislative update, Kyle?
Yes.
Yes, there are really not really any updates for the board. The only update would be that, as you all probably are aware, is legislative session will start at the beginning of the year, and, we expect there could be some stuff as there has been in the past related to contractors. So I would just expect that to potentially happen in the next few months. But nothing's been brought to my attention yet.
Okay.
And then I think it'd be pertinent during this time, we next meeting, we will probably have some rules to present to you guys. So just so y'all are aware, we're looking at some rule amendments for initial approval. And I believe we have a rulemaking hearing set for January on some prior rules that were already in the pipeline that will be fully approved or will be considered during that rulemaking hearing.
That'll be during our regular board meeting or a separate meeting?
Yes, Mr. Chairman, during the regular board meeting next month. Excuse me, January.
All right, Chris, do you have some updates for us?
Yes, Mr. Chairman, just referring to this document here, just continue to talk about their, increased year-over-year increased amount of initial applications that we're receiving in 2024. That we've already surpassed what we did total of all last year already. I know we're getting to the end of the calendar year, but we are continuing to see, I won't say record, but record applications for new applications. And so, but with that, here comes those turn into, again, renewals. And so we are, continuing to knock out renewals. I would say as a whole, we are on a good trajectory right now as far as approving renewals and initials. Just some anecdotal evidence. This past week I've seen, when I'm hitting final approve on the initial licenses, there's a turnaround of 3 days. And so that's very excellent. And so we have reduced our backlog quite significantly, and we're approving things as they come in and not putting them back at the end of the line. As long as everything is there, we're having a quick turnaround. There's still quite a few, I would say, deficiencies, and those letters are getting sent out, and those are getting turned around with calls or emails to the call center through our Zendesk system, and getting those things updated. But overall, I think we're in a much better place than the board was a year ago. And so with that, I just want to, great job to our staff. And if there's any questions about anything, and I appreciate the turnaround that you have providing approvals back to us. And so that's been very helpful. The amount of complaints, or not necessarily complaints, but just inquiries on how long things are taking has tremendously dropped off to almost nothing. And so we're very, very grateful for where we're at as far as our processing times.
Do we have any backlog on formal hearings?
That we'll have to turn that over to the legal team.
I can answer that. We are addressing that, and in fact, I will say specifically since the last board meeting, in September, we had 15 disciplinary actions. In October, we had 35 disciplinary actions that were reported. And of those disciplinary actions in October, that included the total assessment of $94,408 of civil penalties plus 2 license suspensions. So we are addressing cases that had previously been in a backlog, and we believe that probably by the end of next year, we will have completely removed that backlog of cases as we continue to set cases.
Talking about the end of next year?
I think by the
It's
end
gonna
of next,
take-
yes, by the end of next year, I think we'll have resolved all of those cases that that are a little bit aged, closer to a year old. So we are continuously getting cases set for hearing, getting them settled, or if facts have changed, getting them represented so the board can reconsider the updated facts.
So we're a year behind.
Well, we had been more than a year behind, and we
Okay.
are
Yeah.
doing, I mean, I think our litigators are doing a great job of getting those cases resolved. And I will add as well, from the last board meeting, we had a total of 45 complaints that were open. So I know we've looked at that on a month-by-month basis of how many new complaints are being filed. And I think the fact that, we had 45 cases that were opened, the legal report is about the same as in length as it's been on a month-to-month basis, but we are resolving more cases by statutory citation. So they typically do not have to go to a formal hearing. And then we're resolving many more cases by settlement or individuals who have applied for a license and can have that case settled through receiving that license and a penalty paid with that.
Any other questions?
All right, we'll move on to new business. BCA little r with incorrect limits.
I'll start off here, and then Kyle can, we're kind of work together on this. There was an issue that came up, in particular, one particular case that came up about a mismatch in the license modification of the BC little r, which is, has by statute, a monetary limit of $125,000, but on the license, they had a limit that was much higher than that. And so we went back and did some research on that particular one, and we also went through and did a holistic search through all the active licenses to include expired grace licenses that could potentially have that. And there was about 40 or so but we went back and looked at the administrative data, the application data, and we cleaned up all of them but about 6. 6 of those that had some type of approval or could not determine that it was an administrative error on the staff side about issuing that license with a monetary limit. Or had a I don't think it was anybody on this currently serving on this board, but had approved them at a higher limit for a BCAR, higher than 125 that was approved by a previous board member. So we sent out a notification letter to all of those 6 licensees to let them know that we're going to be discussing this today at this board meeting. But my recommendation was to them is we will either take the test to get the BCA exam and keep the current limit, or recommend that we have to revert back to what the law of the statute says and administratively adjust their limit back for the BCAR back to 125K.
And I can jump in a little bit. The crux of the matter is that we've discovered 5 or 6 licenses that or monetary limits that were improperly granted. They should have not been granted. You all know that the BCR limited residential, the little r, by statute and rule can only go up to 125,000. Well, there's multiple licenses that have that. So what we did is we gave them an informal option. They can agree to lower their limit. That's no adverse action. If they agree to lower their limit, great, to come into compliance with the statute. It was also going to be our recommendation to this board that they be allowed a certain time frame to take the full BCA exam and get back into compliance that way. Because if they take the full exam and then it can be reviewed again and make sure they have a monetary limit that is in line with everything else, then they're good to go at that point as well. And where we also needs the board's input and really authority is if we do have any of these individuals that do not agree to those 2 different avenues, then we would want the board to authorize complaints against any of those licensees that do not agree to it or do not agree to come back into compliance by testing. The board cannot unilaterally lower their limit, there's a specific rule and statute. They have I know it's a little bit convoluted, but the license to us was improperly granted according to law, but now they have a property right in that license. And by rule of the board and by statute, the board cannot take adverse action against that license without the opportunity for a formal hearing. And that's the reason a complaint will have to be established if they do not agree to this with the purpose of lowering their limit. Does that make sense? Do y'all have any questions about that?
What kind of time limit were you thinking of giving them?
We had 90 days from today to take the exam. But we give them a letter, about a month ago, so they've really had more than 90 days to prepare for that if they so choose.
What kind of limit did we give them, or does it vary?
Some of them varied. One was 250, and then some of them could say that was up to $1 million. And I don't have all the specific ones in front of me, but I can follow up with you.
Kyle, it looks like we have somebody in the audience that wants to say something on this issue. Is that permissible?
No,
We can discuss that.
we
at the
can
public
discuss
comment
it,
period.
yeah, after, okay.
Okay.
Any more questions from the board members on that? I think what we're looking to see is maybe get a decision on that time frame, and then a decision on if no one agrees to authorize complaints to take, adverse action against the license.
The only one I would have, there should be a third option, and that's to, appeal to the board members for the waiving of the test for the BCA, which, that's depending on the circumstance.
Okay.
That would be their third option.
So you want to add a third option? Okay.
Yeah, depending on the circumstance, that could be fair.
So I think what we would do is probably send out a new letter to those licensees and adding that third option. So the board wants to give these individuals those three options, and if they do not take one of those informal options, authorize complaint against the license.
I'm assuming they would be allowed to complete any work under contract that they currently have.
Before adverse action is taken against the license, they have that license with the monetary limit.
Okay.
But that's 90 days, right?
I think it would be 90 days for them to get into compliance with the testing, or whether they want to have a meeting to waive the exam portion. So that would be the options. Does that answer your question?
So if they could get finished with the work in 90
Well, I was going to say,
days.
if they could get through with the work that they have, they may decide not to renew the license or whatever, and they may decide just to complete what they've got, and that could take longer than 90 days, I guess is.
That may, and then if they end up not coming into compliance, a complaint would be established. But if they're not working anymore and their license is expired, we'd have to address that at that point to see if it's even worth pursuing. But
Yeah.
Well, the option to appeal to the board could take a whole lot longer than 90 days, I would think.
Well, the 90-day mark is mid-February at this point, and so that they can come, interview at the next, the board meeting in January, if they so choose, I guess.
Okay.
so I think we will need a vote on what avenues you want to give these individuals, and if they don't take one of those avenues, whether you want to authorize complaints against the licenses.
Okay. Somebody want to make a motion?
Well, can you address this when they come up for renewal?
We could, but we'd be in the same situation.
We just wouldn't renew it for,
That is a good point, Reese.
just a thought.
Jesse, do you have any thoughts on that?
We can look at that. The rule does require, either they consent to that adverse action. So essentially, if we would look at it, and that's where it's going to be a little bit strange, because they'd be submitting a renewal for a BCA little r, so they likely, I don't think that their financials they're going to submit would be the same as if they were renewing for a $3 million project potentially, which, because some of them do have large limits. So we can look at that.
I think for now, that would still be considered adverse action, because we basically limited their license, taking adverse action during that renewal period. So I'd be concerned that we would be crossing the border of the statute and rule that says that we can't take adverse action without a formal hearing.
But I do think it's worth adding, and back to the point about the 90-day period and the work that they can do, even if their license limit was lowered back to that 125 under the rule for that monetary limit, they would still be able to potentially continue any projects they have on now. So even if we did take action against their license, they agreed to lower their limit, we would have to look to see what types of projects they're doing. If they're doing $1 million projects and they don't think that they could finish that within the next 90 days, then they might want to look at changing their license to a full residential, or submitting what they need to do to have an exam waived. But on the other side, if they're doing projects that are within that 125 limit, they may just decide to let their license be lowered to that 125 and continue to do the projects they're doing. I think it'll probably be a case-by-case basis for these individuals.
So you had like 40 of these originally, and you're down to 6 that didn't agree to do one or the other?
Well, I think the original list was down significantly because it was more of an administrative error. They actually applied for a full BCA, and somehow it got put in as a little r in the system. So those could be cleaned up administratively, and that really dropped down the list.
Okay.
And then I'm not sure after that if there were individuals that have already agreed.
Well, it was just a matter of, we could not determine on the license that it was, where it was approved at, the limit of 125, because they had other modifications, modifiers in there, and then there was just a complete approval of a license at the, this is, for example, $2 million limit, but, with the other modifiers, you were allowed to have a $2 million limit, but the BCAR was not, specifically said, 125, but I think there was one particular case where they only asked for a BCAR, and they were granted, I don't know, a 250K limit. And that was from a previous board member. And so we have to, and that's kind of the cases of the six we couldn't just, adjudicate
Okay.
on our own.
And it's good we caught this, because where it came up as a local codes office jurisdiction was concerned about it, because they knew the rules of the 125, and that's when all this was discovered. So it does need to be taken care of, because it can cause problems with other local jurisdictions and what they are approving or not.
If you only have 6, what is their financial status? I mean, if hypothetically, let's just say somebody got $1 million license, they have assets of 100,000. I mean, have y'all looked at that too? I think that's a big.
It's fine. I mean, they're active licenses, so if they have that limit, above at 125, so their financials are in good standing. It's
Okay.
just, a matter of the
Exam.
experience or the exam that they haven't taken.
All right, we need a motion.
Can you give us the three?
I can
let's-
clarify
Why don't you,
for
yeah,
you.
why don't you read it off to us again? We
So
can
the-
recite it back to you.
The motion needs to be for these individuals that were improperly granted a monetary limit. The board would give them 3 different avenues, one being that they agree to lower their limit in compliance with the statute, 2, that they agree to get into compliance within 90 days by testing and becoming a full BCA. 3 would be the other avenue of coming in for an interview to consider waiving the exam. And then if they do not agree to come into compliance by any of those ways, the board would authorize a complaint to take adverse action against their license. So that would be the motion.
I make a mo.
Any other discussion? All in favor, say aye.
Aye.
That motion carries. reciprocity with Alabama and Mississippi.
Yes, there's been two requests that's been brought up over the last couple of months as I've gone and met with some other states, and they've taken opportunity to reach out to me. One is with Alabama. They do their boards differently than we do. We're all kind of consolidated into one board. They have different boards for different things, and then in particular, the HVAC and air conditioning board had reached out to me and wanted to establish I think we have a previous reciprocity with Alabama, but not necessarily with HVAC. They wanted to establish a reciprocity agreement with us. And I had the legal team look it over. I think there was one clerical thing that we fixed with Alabama about residential, because we didn't, HVAC is HVAC. It didn't matter what it is as far as the type for Tennessee, and that was removed. But we're looking for either discussion, we can continue to discuss this, or a motion to approve to move into a reciprocity agreement on the HVAC and air conditioning and heating with Alabama. And then the second one is more or less an update with Mississippi. And I think we've had a reciprocity agreement with them for a number of years, a long time, at least 20. But wanted to kind of refresh that and update that. And basically, whatever they have in Mississippi, we can and reciprocate with Tennessee. And I don't think there was any there was no major changes from what was previously agreed. I guess it's just time and space between signatures. They just wanted to update. And I don't know if legal team has any other.
I don't have any other
updates on
comments.
it.
The board
Yeah.
has those agreements in front of them, correct?
Yeah.
Okay.
I make a motion that we accept the reciprocity agreements from Alabama and Mississippi as presented.
Any discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. The 2025 board meeting dates.
All right. I think we have in front of you as well a list of dates, and they were very closely aligned to what has transpired in 2024. So if there's any questions on those we can go through date by date, but they were pretty much very much aligned with what occurred this year with the West Tennessee in May and East Tennessee in September. The same schedule, basically. Is there any questions to go in, anything particular? I think the only one kind of different is this meeting. The November one's held a little bit earlier just because of the Thanksgiving holiday, but all the other ones were at the end of the month.
We need to have that as a formal motion then, the dates, or?
Yes.
Okay. Somebody want to make a motion on the dates?
I'll make a motion that we accept the board meeting dates as presented.
Second.
Okay, any other discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries.
You're gonna send that out like you did last time, where it goes on all our calendars?
Yes. We'll figure it out. Kathy will do it.
All right, the last item on the agenda are public comments. I think we have somebody that wants to make a public comment. Come up to the podium if you would.
Good morning, everyone. My name is Billy Irby. I'm a licensed contractor from Memphis, Tennessee. Thank you all for allowing me to come and speak. I'm one of the licensees that has an issue with the monetary limits on their contractor's license. I've been holding the AR contractor's license since 2011. At my initial reviewing of my application, a board member informed me that within a year after a year that he would grant me a full license. So in 2017, that's why I applied for a monetary increase because of the size and the opportunity that was available for me. 2023, I started studying for the combined commercial and industrial license, which will be a BC, B, C combined commercial and industrial license. I studied for 12 weeks, and I took the test, and I passed the combined commercial and industrial license. This license, according to what your monetary limits, not your monetary limits, but your financials will allow, will determine your monetary limits. So there's not a limitation under the combined commercial and industrial license. Just a little bit about me and the background that I come from. I got my experience from the local 345 carpentry unions where I was a carpentry apprentice, and I had the pleasure of working for a company called Ravensburg Incorporated based out of St. Louis, Missouri, where we performed the erection of laboratories and casework for St. Jude and their Chili's building and their study cares and their psychotron levels or whatnot. I advanced pretty fast in my field because I love to learn. At a given point, I started pursuing creating my own procurement so I can create workforce development opportunities in my community where I come from. I come from an urban area that's pretty much deprived from a lot of opportunities for us. I've worked closely with very well-known, established companies within our community, such as Habitat for Humanity, the Community Development Agency, which is the CRA, the Works Incorporated as well, where I perform and spearhead a large amount of redevelopment of residential properties and so forth. In these properties, I was able to, like I said, create workforce development training to the youth in our area just to give them exposure, something that we're very much limited to in our community. Recently, through my work, I've experienced extreme stress levels and anxiety, where I kind of like overworked myself and so forth. I ended up in the emergency room because I was having muscle spasms in my neck on the left side. And this was about 4 weeks ago. I couldn't open my mouth. My face was twisted. My head hurt really bad. My brain felt like it was swollen. And they basically told me that if I was to ever experience stroke-like symptoms, to immediately come to the emergency room or whatnot. In my case, I was experiencing facial paralysis, and it can also be classified as Bell palsy. This condition usually takes 6 months to a year, and a lot of people who experience this condition don't have a full 100% recovery. Through holistic treatment and acupuncture, I'm at like a 90% recovery rate within 4 weeks. Putting myself in a situation to where I have to do restricted study, basically putting myself in airplane mode again to test out for the full residential license. In my condition, I feel I wouldn't be able to test out as proficiently as I could if I wasn't experiencing what I'm experiencing now. They've noted that there are several contractors that has incorrect monetary limit, but I'm basically the only one here at this time. I take pride in what I do. I hold myself to all ethicals. I have continued to apply myself and to get additional education. After passing my combined license, I pursued and got my OSHA 30, so I can create and make sure that I implement safety protocols and be aware of industry safety procedures and so forth. I also went past it and applied myself and got my CPR and AED defibrillator certification, so I can make sure where I'm spearheading a project that I can attend to, oversee, or give just the basic knowledge on what we should do to help someone recover in the event that a mishap happens on a project. Again, I'd just like to say that I now hold a Tennessee combined BC, B, and C license that I was able to get this year, and the AR license is a license that I got in 2011. I'd like for you all to take consideration into making the best decision moving forward, because this will greatly affect the opportunity that I can create in my neighborhood, in my community, in my city, if I was limited back to 125,000 residential license. That's all I would like to say. Thank you.
It sounds like we're going to have interviews at our next meeting to make those decisions if you want to go that route. Ask the board for approval without taking the exam.
What's the limit on his BC?
Right now, my limit is at $450,000.
Okay.
And regarding those interviews, I think he traveled from Memphis, so we could set those up online if someone's requesting to interview and for the board to consider waiver of the exam.
Can we waive his requirement now since he already traveled or is it?
Right. If he's past
here?
BC,
Yeah, if he's past
there's
the
no good home
450.
builders. He can pass that.
I think since the board just made that decision to give those people the avenues, I think you could consider that right now and take a vote on it. Yes.
Well, I'd make a motion for this licensee to be exempt for the BCA exam and grant him BCA for $460,000. Was that the number?
We'd want to check on that, but I would just say whatever his current monetary
Yeah,
limit
right.
is, yes.
That would be my motion while he's sitting here.
I second it.
All right, any other discussion? All in favor, say aye.
Aye.
Any opposed? All right, that motion carries.
We want to continue with, is there any other public comments, I guess, from online before we? You see anything in the chat?
There is nothing in the chat.
Okay. Being no other public comments, then we will adjourn.
Make a motion, we adjourn.
Second.